David is like Fidel Castro. He can speak also for hours and hours.
Is this on? Thank you, Carlo, Valeria, and Francesco, for your very kind words. Much as I'm sure everyone is intensely interested in oil major approvals, I shall try and skip through my presentation quite quickly. But if anyone wants a copy of it, they can email me and I will send the full presentation. Oil major approvals is really another aspect of what we were talking about in the last session of the great fear and concern of the oil majors, who have tried to distance themselves from any liability. If there is one thing that you remember about what I tell you tonight, it is that in the tanker market, oil major approvals are absolutely critical and fundamental. Quite simply, if you don't have oil major approvals and you're an owner, you will not be able to charter your vessel out. And if you're a charterer, you will not be able to lift cargoes and trade. In fact, a sign of the fundamental importance of oil major approvals is that the most widely used form of charter party, the Shell Time 4, Clause 43 gives the charterer an express right to terminate the charter if the vessel loses oil major approvals. It's the only clause in the whole charter party that gives the charterers a right of termination. So that is the wording of Clause 43 of the Shell Time 4. If at any time during the charter period the vessel becomes unacceptable to any oil major, charterers shall have the right to terminate the charter. Clause 43 itself doesn't define what an oil major is. One of the most curious aspects of oil major approvals, given the fundamental importance, is that until very recently there was almost no English case law or guidance. In fact, the only reported case was a Sea Flower, which didn't really clarify the position. But actually in the last year or so there have been 3 cases that have clarified many aspects of oil major approvals. The first one was a case where I acted for the charterers. It's LMAO arbitration, so the full details are confidential, but it's been reported in Lloyd's Maritime Law newsletter. The second one is the Savina Kalin, which has since become more famous for other reasons. And the third case is the Rowan. So I'm just going to go quickly through those 3 cases. The first one, the arbitration case, had as is very common, a modified Clause 43. And I will have to go through the wording, unfortunately. It's a bit heavy at this time of night, but it said basically, to the best of the owner's knowledge, at the date of this charter, the vessel is acceptable to BP, Exxon, Mobil, CDI, Cepsa, Shell, Statoil. And then it went on to talk about getting other approvals, and particularly Total and Ritza. And then the key wording, it said, if at any time during the charter period the vessel has less than 3 oil major approvals, charterers shall have the right to terminate the charter. What happened in that case is the charterers tendered the vessel to lift various cargoes of oil majors, and the vessel kept being rejected. And they asked the owners several times to clearly state what approvals they had. And eventually the owners came back with the following list, of which they said 4 approvals: Innovine, BHP, Rightship, SGS and CDI. In the arbitration, it was very useful because the owners basically advanced almost every possible argument that could be advanced, and so the tribunal had to consider them. The main argument of the owners was they said that an oil major under Clause 43 meant a major producer of petrochemical products, or charterers of petrochemical tonnage, or vessel assessment and approval agencies to which such parties delegate assessment of the suitability of a vessel. That argument we had quite a bit of fun with in the arbitration. We said that under that definition, for example, L'Oreal in Paris, because they're worth it, would be an oil major because they were a producer of petrochemical products. Brooks Bell would be an oil major because assessment and approval was sometimes delegated to them. The second interesting argument the owners ran was that they said that under clause 43, the owners didn't have an absolute obligation to obtain oil major approvals. They only had an obligation to exercise due diligence, slightly reminiscent of seaworthiness. And they said that in that case, because of the trading patterns, they couldn't get oil major approvals, but there was no breach. Thirdly, the owners said that the charterers should have known that they didn't have approvals, and they ought to have cancelled earlier. And because they didn't cancel promptly, they lost their right. And finally, they argued that after termination, the vessel was accepted by other oil majors. So the decision of the tribunal, they held that in fact none of the four companies were oil majors. Major producers or charterers of petrochemical tonnage are not an oil major, neither are companies like BHP Rightship that do assessments of vessels. So the owners failed. The tribunal also held, in effect, that the obligation was an absolute one on the owners. It wasn't just an obligation of due diligence. On the waiver estoppel, the tribunal held that it was only when the charterers had received the list that I showed you earlier that they really knew the true position, and they did exercise their rights promptly. A couple of points that weren't looked at in that case, one of them that has been picked up very strongly in the Rowan case is what oil major approval means, and I'll go on to look at that. The other question that is open is, can charterers also claim damages in addition to cancellation? And the charterers didn't pursue a damages claim, but in our view they could have done, because the vessel kept being rejected and they had to lift less profitable cargoes. The second case, again, was a modified clause 43, quite a specific wording. So in this case, it said, should the vessel be failed on 3 consecutive oil major vetting reviews due to owners or vessels reasons, charterers have the option to put the vessel off hire or the option to cancel. Importantly, the wording said a vetting review or inspection is defined as a nomination by the charterers to an oil major, and the oil major reviewing the vessel by physical inspection or sire report. One of the points there was the owners said one of the rejections by ConocoPhillips were not an oil major, and the tribunal held that ConocoPhillips were an oil major. Another point the owners raised was the list of rejections. In between the list, BP did approve the vessel, but that was a result of a unilateral approach by BP to the owners, not a nomination by the charterers. And on that, going back to the wording, it said quite clearly it must be a nomination by the charterers, so that didn't help the owners. And the owners thirdly argued that there had to be a consideration of the sire report as a reason for rejection, and there was no evidence that the oil majors had considered the sire reports. Again, that went very much on the specific wording, but again the owners were not successful. So again, in the second case the charterers won that case. So going on to the last case, the Rowan case. Again, it's important to emphasise in these cases, very often the charter wording is a unique one or is changed, and a lot depends on the charter wording. But in this case, there were 2 slightly conflicting parts of the recap. The first part stated to the best of owner's knowledge without guarantee, vessel is approved by BT, Litasco, Statoil, Exxon. But the recap went on to incorporate the charterer's standard terms, and those terms said owners warrant that the vessel is approved by the following companies and will remain so throughout the charter party. And then again it said to the best of owner's knowledge, and it gave a list. There were three real issues in dispute. The first was again on the wording of the charter party, and the owners said, well, the wording said without guarantee, therefore we can't be held liable for lack of oil major approval. But the court held that that clause didn't override the clause that incorporated the charterer's standard terms, and that had a second and independent oil major approval clause. The second point I'm just going to skip over is that the court looked at what the best of owner's knowledge meant and what it required, and it said it didn't impose an obligation on the owners beyond the extent of their actual knowledge, and it didn't require them to make inquiries additional to those that would be made ordinarily. But it was held in that case the owners had breached the charter party because the problems with the vessel were so severe that they must have known that the approvals couldn't be in place. And the third and final point, which is by far the most interesting and relevant, is that in that case the court looked at in detail what oil major approval meant in the current market. And the charterers argued that actually all the approvals that the owners had didn't amount to anything, because all of them said, the oil majors, we don't approve this vessel, we don't commit ourselves to anything. If you tender the vessel to lift one of our cargoes, we might think about lifting a cargo. And that's all they ever had. So the charterers said, well, they never had any oil major approvals. And the court looked at that in detail and they said, no, that is all that you get in the market today. That is an oil major approval as it is understood, particularly post-Erica. So the court said that approval meant acceptable to an oil major who might or might not, when the prospect of a real transaction arose, decide to approve the vessel. But it was not the practice of oil majors to grant approvals in advance, and express approvals were only given for specific voyages. So it's the first detailed examination by the English court of what obtaining oil major approvals mean. And in my view, it is an accurate and helpful statement of the industry practice. And it is the one part of those three cases that I think is worth owners and charterers actually reading. And if any of you want a copy of that, I'll be happy to send it to you. So that's basically all I have to say, just to re-emphasise that oil major approvals are absolutely critical. Do look at your charter wording very carefully, and do be careful that if you're an owner, you're able to get and keep your oil major approvals. Thank you.